It's not about hiding your wealth, it's about making it untouchable. Because here's the thing, hiding assets makes you look guilty. Making them judgment-proof makes you look smart. And today I'm going to show you how the wealthy protect what's theirs. Enjoy it every day and still keep it out of the reach of lawsuits. Hi, I'm the business guy, the CEO of the Lawyers Limited Law Firm and Asset Protection Planners. I've been in the asset protection business for 34 years and setting up Cook Islands trusts for nearly 30. We've set up more of them than anyone else in the world. And in this video, I'm going to break down how to legally separate ownership from control so you can drive the car, sleep in the house, spend the money without a creditor ever being able to touch it. So if you want the same strategies for yourself, visit assetprotectionplanners.com for more free information or to speak with one of our professionals. Now let's get this straight. Hiding assets is a bad idea, not just morally in many people's eyes, but strategically. If you're in a lawsuit and suddenly your name vanishes from property records, bank statements, or investment accounts, guess what? That's like ringing the dinner bell for opposing counsel. They'll just dig deeper, subpoena harder. And if they catch you trying to conceal ownership, you're looking at potential fraud claims, sanctions, or worse. That's why the wealthy don't hide, they reposition. They make it so they legally don't own the asset, even though they still enjoy every benefit of it. And that's the difference between looking like you're dodging and looking like you've done smart planning. Now here's the mindset shift. Ownership and control are two different things. When you own an asset outright, a court can take it from you. When you control an asset that's legally owned by a separate, properly structured entity, you still get to use it, but it's outside your personal legal reach. Example, a wealthy client of mine, we'll call him Daniel, had a vacation villa in the Caribbean. He loved spending his winters there, but his U.S. business was in a risky industry. Instead of putting the villa in his own name, we placed it in a local LLC owned by a Cook Islands LLC, owned by a Cook Islands Trust. So Daniel was the manager of the LLCs. He decided when to rent it, when to visit, and how to maintain it. Then came a 7-figure lawsuit back in the States. The plaintiff's lawyer saw no real estate under Daniel's name, no vacation property to lien. They didn't even know where to start. So Daniel still flew down every December, still hosted friends, but on paper, it was never his to take. Now there's a reason why this works, even if a U.S. judge orders you to hand it over, and I'll explain that in just a moment. When you're the legal owner, you're vulnerable. If a court judgment is entered against you, the sheriff can seize your property, the court can freeze your accounts, and your name is right there in the public records. But if your trust owns it and your LLC manages it, the legal picture changes. In our offshore structures, you're the manager until a threat appears. And if that happens, our licensed bonded trustee company law firm in the Cook Islands steps in temporarily to shield you from being compelled to act against your own protection plan. So here's why this is the key. Under U.S. law, a judge can order you to turn over something that you control, but they can't order you to hand over something that you don't control. Now keep in mind, this is the most highly regulated, reputable trust jurisdiction in the world. That's the legal firewall the wealthy rely on. Now remember, this isn't hiding. Everything is properly titled, properly reported, and 100% legal. It's just titled in a way that U.S. courts can't touch. Once I worked with a retired tech entrepreneur, let's call him Alex, who owned a 92-foot yacht. He had been through the messy lawsuits before, and he didn't want to repeat the experience. So we placed the yacht in an offshore LLC inside of an offshore trust. So on paper, Alex didn't own it, but in practice, he still used it for Mediterranean cruises every summer. And a few years later, somebody tried to sue him over an old investment deal gone bad. Their attorney found the yacht registry and saw that it wasn't his. So they asked the court to compel him to make it available to satisfy the judgment. Now here's where the offshore structure worked perfectly. Alex wasn't the owner, and by the time the trustee was notified, control had shifted. The court order had zero power in that jurisdiction. So the yacht stayed where it was, Alex stayed on deck with a cold drink, and the plaintiff walked away with nothing. But here's the catch. Do this wrong, and it can actually increase your legal risk. And I'll tell you the most common mistake in a second. Now, the biggest mistake I see is people transferring their assets but keeping everything else the same. So they put their house in their cousin's name, but they keep paying the mortgage, taxes, and repairs like it's still theirs. They sell their business on paper to a buddy, but they still sign the contracts and run payroll. And courts see right through that. It's called a sham transaction. If you're not following the rules of ownership, the law can treat it like you never transferred at all. And that's why the structures that we build are real, registered, and administrated in jurisdictions designed for this purpose. The separation isn't just for show, it's legal reality. Another legal truth: the earlier that you act, the safer that you are. Now, if you wait until you're already being sued, you run the risk of running into fraudulent transfer laws. Some jurisdictions, like Belize, have no statute of limitation on transfers into a trust, which can help in emergencies. But the gold standard is to set things up long before you need them. So think of it like insurance. You don't buy fire insurance after your house is already on fire. You buy it when the skies are blue. Now, here's the beauty of doing it right. You don't have to give up your lifestyle. You can still live in the home, drive the car, use the yacht, draw income from the investments, but because you've separated ownership from control and placed ownership offshore in a protective jurisdiction, you've effectively become judgment-proof without going into hiding. To the outside world, you simply look like someone who lives well, and to the legal world, you look like somebody without collectible assets. Okay, now you might be thinking, can't I just do this in the US? Yes, but with less protection. Domestic structures can be penetrated by domestic courts. If the judge has jurisdiction, they can compel you or your US trustee to hand over the assets. Offshore jurisdictions like the Cook Islands, Belize, and Nevis are different. They don't recognize US judgments. They require plaintiffs to start from scratch under their laws, in their courts, in their jurisdiction, with their proof standards. That creates a fight that most lawyers won't take on. So here's your move. Stop thinking about hiding assets. Start thinking about structuring them so that you can enjoy them without owning them in a way that makes you a target. And that's how you become judgment-proof without disappearing from sight. So feel free to go to assetprotectionplanners.com and let's make sure that your lifestyle stays yours no matter who's coming after you.